We're on the record in case 24 CRI 157, caption State of Ohio versus April Parks. Here for purposes of a bond setting on a complaint that was filed earlier today. The defendant is present. We're conducting this hearing by video. Appearing on behalf of the State of Ohio's prosecuting attorney, Christopher Tennell. Ms. Parks, do you have any objection to the court conducting this hearing by video?
No, video is fine.
Okay. Did you get a copy of the complaint that was filed?
Yes, just now. Clear.
Court has to go over that with you. There's one count. There's cruelty to companion animals, a felony of the 5th degree. It reads on or about April 30th of 2024 in Ashland County, Ohio. April Parks did knowingly cause serious physical harm to a companion animal, to wit, a cat, in violation of Ohio Revised Code section 959.131, 959.99E2, cruelty to companion animals, a felony of the 5th degree. Do you understand what the state is alleging in the complaint?
Yeah, it's not true though, but yeah, I understand it.
Okay. You have certain rights in this matter. First, you have the right to remain silent. Anything you say during the course of the hearing could be used against you at future hearings. You have the right to have an attorney, and you have the right to a court-appointed attorney if you cannot afford to hire your own and you qualify. There is a $25 fee for a court-appointed attorney. You also have the right to have a preliminary hearing since you're charged by complaint, which is a probable cause hearing. You also have the right to have a jury trial and to have the state prove your guilt as to the charge beyond a reasonable doubt to all 12 jurors. Do you understand those rights as I've explained them to you?
Yes.
Okay. Did you want to be represented by an attorney?
Yes.
Okay. Can you hire one, or did you want me to consider you for court-appointed counsel?
I'm not sure how much it's going to cost. It depends. I am not sure. I would have to look into that to see if I could hire one myself or not. I'm not sure.
Okay, well, we're going to set bond today, so we can do that first. And if you decide you want a court-appointed attorney after that, the court can address it at that point. Okay.
Okay. Yeah.
All right. The court's going to address the matter of bond now. The court's going to let the state of Ohio go first. Ma'am, if you want to say something, you can after the state is completed. Attorney Tennell.
Thank you, Your Honor. Your Honor should be aware that on April 30th of this year, the Sheriff's Office received a 911 call reporting that the defendant, April Parks, was having some sort of mental health crisis. She had picked up some high school boys from school, which is apparently normal routine, but was acting erratically and in a manner that caused them grave concern. Deputies arrived at the residence at State Route 302 in Ashland County and found Ms. Parks and agreed that she seemed to be having some sort of situation. It was brought to the officer's attention by the boys that she had killed the cat. At that time, officers noticed there was a significant blood trail leading into the house, into the kitchen area, and under some towels on the counter, they found the body of a black cat. It had been stabbed. It had been stabbed several times, and in fact, a large chef's knife had been inserted into its skull through its mouth, all of which is attributable to this defendant. The defendant, per Oleg, says that there's a 2004 Ashland County Common Pleas conviction for what's referenced as felonious assault, but it says F3, so I don't know if that's an attempt or just what that's about. And the docket doesn't disclose what the actual charge was, other than the original charge was felonious. The state, as far as bond, would ask that she not be in possession or near or around or care for any animals whatsoever, that she receive some form of mental health assessment if that hasn't already occurred, and comply with any reasonable requests stemming therefrom, including if they want to medicate her. The state would ask for the court's standard conditions of bond and recommend $50,000 cash.
All right, thank you, Attorney Snell. Ms. Sparks, if there's anything you'd like to say before the court sets bond, the court can only set bond today, not decide the facts of your case. You may do that now, but I'll just remind you, you don't have to because you have the right to remain silent. So if you'd like to talk to an attorney first, you can do that. Is there anything you'd like to say today regarding just bond?
I can't afford $50,000. I don't know. No, I don't know what to say.
Okay.
Um,
All right, thank you, ma'am. Court's going to set bond as follows. To be released while the case is pending, you'll have to post 2 bonds. The first is a personal recognizance bond. It's your written promise with the court to appear at all future hearings in the case. If you violate that bond, you can be charged with a separate felony offense for failing to appear. The second would be a surety bond, a bond secured by real estate or securities as allowed by law, or the deposit of cash, the amount of $50,000. Conditions of bond are that you not leave the state of Ohio without obtaining written permission from the court, appear at all future hearings in the case, and keep the court informed of your current address and telephone number at all times. Need to follow and obey all laws of the state of Ohio and orders of the court. Do not use, consume, or possess any drugs of abuse or alcohol and be subject to random drug and alcohol testing. Cannot use products containing THC while you're on bond. Court's going to order that you seek a mental health assessment from a properly credentialed treatment professional and comply with their recommended treatment plan. If that treatment plan includes medication, you'll comply with the treatment plan. You need to make the appointment within 14 days of posting bond and provide verification of the court regarding that mental health assessment. Where it's also going to order that you have no possession or be in any care of any animal. And that includes pets, livestock, any animal as a condition of bond. Do you have any questions about the conditions of bond?
no.
Okay. Having set bond, did you want the court to consider you for an attorney at this point, a court-appointed attorney? Or did you still want to call whoever you need to and check into it, or?
Yeah, it depends on how much it's going to cost is all.
Okay. Well, I can set this for another hearing on Tuesday and see where you are with counsel. If you decide you want court-appointed counsel at that point, the court can appoint an attorney for you if you qualify for court-appointed counsel. Do you understand that?
Yeah, but could I still do the bond today though? Depends.
I'm filing the bond order today, yes, yeah. So if you want an attorney today, that's not going to delay this anymore. But if you want to look for your own attorney, I'll give you time to do that. And we would we have to set another hearing anyway for next week for an initial appearance, so. Did you want to?
Not yet. Oh, I would rather wait if I could go ahead and do the bond first. Yeah.
Okay. All right. All right, we're going to set this for Tuesday, May 7th at 2:30. Does that work, Attorney Snell?
That should.
All right,
Yeah.
we're set at Tuesday, May 7th at 2:30 p.m. And we can further address, I know you want to be represented by counsel, we can address that further at that time. If you bond out, come to the courthouse for that hearing. That's a court hearing, so come to the courthouse for that. If you don't bond out, then we'll have you by video. We'll address the issue of your attorney at that point. Okay?
Okay.
Do you have any questions on anything?
How much is it for the bond to bond out?
$50,000.
Your Honor, you said 2 o'clock on May 7th,
Two,
correct?
I say 2:30? 2:30.
2:30, okay, thank you.
All right, we'll see you next Tuesday at 2:30 then for initial appearance. We're adjourned for today.
Your Honor,
Yes,
could the record reflect time for prelim told based on the council situation, at least through May 7th?
it will.
Thank you.
Court will time that's told the time for preliminary hearing based on defendants seeking counsel. All right, we are adjourned for today. Thank you.
Thank you, Your Honor.